for your presentations. I'm going to talk a little bit about the European Union's approach to international law, and I'll explain a little bit why I think that's important and relevant. But before, or as a kind of bridge to doing that, just to pick up on a couple of issues that the others have raised. I think one thing is we have to be careful that in seeking to defend Israel, that we don't fall into the trap of making exactly the same mistake that we accuse others of, and that is by taking a view which supports Israel for the sake of supporting Israel. I think we have to be very careful when we talk about international law that we're talking about law that applies or should apply, if the rule of law means anything, to all peoples and all states equally. And Israel is one state, but it's not the only actor in this on this stage. And we'll come back to it. But what is the legal position of the Palestinians? And it's they're not a state, but they are a people, and there are legal issues in relation to them as a people. There are legal issues in relation to individuals, which raise international law issues. So that's my first point, that we're just careful that we don't slip into the same problem. The second, I think, which introduces Europe, and that is the issue of legitimacy. When we use law and we use legal language, we tend to be giving legitimacy to a particular point of view. And I think, from my perspective, that's one of the reasons why we think this conversation is important, not because law is so important, but because the way law is used is politically relevant and influential. And I'll come back to that. Now, Europe somehow regards itself as the custodian of international law, which is probably not surprising given that international law as we know it developed in Europe over the course of the 17th, 18th, 19th, and into the 20th centuries. And really, it's only been in the last decades, probably since the Second World War, that that international law has truly become international. And the Eurocentric character of law is reflected, for example, in the fact that here in The Hague, two of the primary international law institutions, the International Court of Justice and the International Criminal Court, are situated in the Peace Palace. And the Peace Palace is a kind of temple of international law, and it's the home of those institutions and others which many look to as being a kind of a source of international legitimacy and law. But I think we're going into a new era of international law. As Greg has shown, I think quite clearly, the majority of states in the UN are not Western oriented. They don't identify anymore with a system that they associate with their colonial powers. And many are non-democratic countries that don't share Western values or ideals, but their views are obviously important and at the end of the day are going to shape and form international law going forward, given that it's states that make international law. Now, ever since the European communities were established in the late 1950s, there have been attempts to talk not just as individual states, the Netherlands, France, Germany, for example, Italy, but collectively as Europe. But really, it wasn't until the 1970s, and it's interesting that Dov spoke about the revolution really that occurred within human rights terms in the 1970s. There was a parallel shift within Europe, and it was in the 1970s that a collective view formed and Europe began to speak as Europe. We know that the communities were formed by the original six, but in the course of 1973, they were joined by three others: Denmark, the United Kingdom, and Ireland. And after the Yom Kippur War of October 1973, a real first European common foreign policy developed. And perhaps not unsurprisingly, the first subject upon which a foreign policy was developed was the so-called Israel-Arab conflict, or Israel-Palestinian conflict, however you want to frame it. And in fact, ever since the Six-Day War, European states had realized they needed a common view which defined their relationship between Europe and the Middle East. And this foreign policy, as I say, developed in the 1970s and really was laid in its most original form in the Venice Declaration of June 1980. And that Venice Declaration really has become the foundation of the modern EU approach to the Israel-Palestine conflict. So let's look at what Europe says about international law in relation to the conflict. And I'm oversimplifying a little bit here, but the European Union adopts three key positions in relation to the conflict. First of all, it says none of the territories outside the Green Line, that is the 1949 armistice lines, belong to the state of Israel. Okay, so they take a view about the territorial status of these territories. They say they don't belong to the state of Israel. Secondly, they say all Israeli settlements outside the Green Line are illegal. And their third position regards Palestine. As we saw, the notion of Palestine developed as a political and legally relevant notion only in the very late 1960s into the early 1970s, when the PLO was created, the Palestine Liberation Organization. And Europe's position since 1973, and certainly since 1980, is that Palestine has to become a state. The PLO, the Palestinians, have a kind of a right to statehood, and that state covers the territory that does not belong to Israel, namely the territory outside the Green Line. Now, this policy is laid down, first of all, by the Council, the European Council of Ministers, of Foreign Ministers, which is a political body. It is the collective body of the foreign ministers of the member states. So they express it in their policy statements, and they do it year by year, and they keep repeating this view. Moreover, they say it's not only a view which Europe expresses, they say these are parameters which they expect Israel and the PLO and all other relevant parties to the conflict to comply with in their negotiations. So they agree that any state that must come into being has to be a result of negotiations, but at the same time, they say any negotiations have to be within certain parameters. And we as Europe are telling you what these parameters are, and they're the ones I've just mentioned. So in a way, they're kind of imposing their view about law on the parties. I'll come back to that. And that policy is then implemented by the European Commission, which does that in several different ways. It can issue instruments like its 2015 interpretative notice in relation to the labeling of products from occupied territories. The Commission also is responsible for administering the financing of the Palestinian statehood project. So Europe, the EU, and the member states together, but also individually, pump millions and literally millions and millions of euros every year into supporting the Palestinian refugees and into this statehood project, building a Palestinian state. And that's the job of the Commission. Then thirdly, you have the European Court of Justice, which is a judicial institution. And the court also expresses this view about international law. So we take, for example, we had the case in 2019 of the Psago wineries, wines produced in the Benjamin region north of Jerusalem, which Israel regards as being outside the state of Israel, are sold in Europe. And therefore, Europe says they must be labeled as being not from Israel, and they're deriving from occupied territories and from illegal settlements. So the court, in a way, echoes and reflects the political view that is adopted by the council and then implemented by the commission, and didn't undertake any independent legal analysis about the status of the territories. It simply said, more or less, because the council and the commission take this view, therefore we as a court adopt that view of international law. Now, a couple of things can be said about that. First of all, obviously the parameters that Europe is adopting and imposing are political parameters. They're not legal statements in a pure sense of the word. And I respect and understand what Dov is saying. We can't completely separate law and politics. But if you look at the origin of the position that Europe took during the 1970s, it was clearly taking a position not because they felt that law required them to take this position, but because they had a political need to take those positions. And obviously everybody knows that Europe was concerned to develop a positive relationship with the Arab world, realizing its reliance on Arab oil at the time. And of course, there was Palestinian terror throughout Europe in the 1970s. Think of the Munich massacre in 1972, for example. So these parameters are, in the first place, I would say, politically driven statements rather than the result of legal analysis. Secondly, Europe has been very self-conscious about this idea of legality. It considers itself to be a kind of, as I said, a kind of custodian of the rule of law. And this is influential within the UN because many smaller states look to Europe for leadership. And they feel if Europe says something about international law, it's probably right. And they'll tend to take it seriously and maybe even follow suit. So I think what Europe says is not only legally, but also politically extremely influential. Now, what does international law have to say then? And let me just, for perhaps 5 minutes or so, just respond to those issues that Europe takes. And here I would say that legal reasoning, for what it's worth, and again, law doesn't provide the answers to every problem, but if we're going to do legal reasoning, we might as well do it properly. Basically, there are 3 steps of applying law. First of all, you have to characterize, frame the problem that you're dealing with. So you ask the question, what is the situation? What is the problem that we are asking law to give an answer to? And then the second thing you do is you look for the legal principles, the relevant legal principles that apply to that relevant situation. And then the third step is to apply those principles to the facts of the situation. That will be a normal way that a court of law would go about applying law, whether in a national or in an international law situation. Now, one of the things we see in relation to the first step, characterizing the situation, is often what has become known as the Israel-Palestine conflict. And again, I would question whether this is just simply a conflict between Israel and the Palestinians, or is it still a broader conflict? We used to call it an Israeli-Arab conflict. And many states of the Middle East have a big interest in this conflict and are very involved in the conflict. Just think of Iran and Turkey, for example, at the moment. The role of Syria is another one. So first of all, this may not be just a conflict between Israel and the Palestinians. And it's also, I think, oversimplifying it to say that it's a conflict between an oppressed people seeking to be liberated from an oppressive occupation, which is kind of the paradigm that was presented to the prosecutor, I believe, over the last years resulting in the prosecutor's request to the courts for a ruling on jurisdiction. And her reasoning, throughout her reasoning, you could see that she has a particular view about this conflict, what it's about. And the paradigm was very much one about Palestinians being victims and Israel being the more powerful oppressor. And I think that this was an issue that arose also in the 2004 advisory opinion, where some of the judges who issued dissenting or separate opinions said, look, the court's majority view is too simplistic. It's not taking account of the historical and political and even religious realities of this conflict. So that's about defining the problem. Secondly, about the principles. What principles then would be applicable to this? Now, we don't have time to go into that in detail, but you have kind of two levels of legal principles. One is at let's say the meta level, the very high level principles. And one of those is the principle of non-discrimination. And that is that, rules are to be applied to all states equally, obviously taking into account local situations, but we can't pick and choose the rules to apply to specific cases. You have to be fairly consistent across the board. And one thing is for sure, that we're seeing law applied to Israel and this conflict in a way that we don't see it being applied to similar or perhaps comparative conflicts. Take, for example, other settlement issues, other occupied territories. There is a principle also of intertemporality. And there's a principle that says, when you're looking at the legality or otherwise of any particular conduct, you look at the law as it was at the time that you're assessing it. So in 1967, for example, the question is, could Israel hang on to control of the territories that it conquered in the Six-Day War? Could it even claim sovereignty over those territories? And that question has to be answered using the law and the principles that applied at that time. It's a little more complicated than that, but that's the fundamental principle. And there's another one that I think Dov referred to, and that is states can't be bound without their consent to a determination of their legal rights and obligations. You cannot impose on Israel or any other state a resolution of its rights and obligations without Israel consenting to be part of the process. And Israel, for better or for worse, has chosen not to participate in various legal proceedings, not in the ICJ, and it's chosen not to be a member of the Rome Statute. And you can't kind of work around the rules to impose on Israel a settlement really of its rights and obligations which are in dispute with another party, as a matter of principle. So if I can just very briefly regard, as I said, Europe took a view or takes a view on three issues: the sovereign status of the territory, the characterization of the territories as occupied and settlements being illegal, and thirdly, regarding Palestinian statehood. These are very interrelated issues, but there are rules of international law which apply to all of those three issues, and they will apply to any conflict that raises similar issues. So when we look at the Israel-Palestine situation, we should use rules and apply them in the same way as we do to other situations. So take, for example, the sovereign status of the territories outside the Green Line. You have a principle called uti possidetis iuris, which has governed the determination of the borders of many, many states throughout the world. It's a principle of international law which basically governs the way borders are determined when a colony is decolonized and becomes an independent state, or when a mandate territory becomes territory of an independent state. And so, for example, the borders of Syria and Jordan and Iraq are based on that principle. Half the countries of Africa are determined according to that principle. So arguments can be raised. I'm not saying they're necessarily 100% right, but they can be raised that the borders of the state of Israel in 1948, perhaps even in 1967, should be determined according to the application of that principle, which is completely ignored by the court in 2004 and was ignored by the criminal court in the recent ruling on jurisdiction, which is a strange thing because, as I think has been mentioned, the courts have tended to completely ignore the mandate and the relevance of the mandate, which is problematic because mandates were legally relevant and are legally relevant. That applies in relation to settlements, by the way. There is no general principle of law prohibiting settlements. In fact, the mandate for Palestine required Great Britain to allow Jews to closely settle the land. Now, the law relating to the legality of settlements is about the Fourth Geneva Convention and the prohibition on transferring population. It doesn't mean every Israeli who lives and works in the territories is illegal. So the general statement that Israeli settlements are illegal is simply not accurate as a matter of international law. Wouldn't be accurate in relation to any settlements or any occupied territory. And thirdly, just to conclude in relation to Palestinian statehood, this is a complicated area of law, but there are principles of law that determine how states are created and when we know whether or not states exist. And this applies in relation to Palestine as it does in relation to any other people claiming statehood or right to self-determination. And so there is no, for example, no general right to statehood. Peoples don't have a right to statehood. The right to self-determination is a very political principle, but it can be determined or satisfied in many different ways. So these are the issues also which have been arising in relation to the ICC discussions in relation to jurisdiction. If Palestine is not a state under general principles of international law, then why is it that international institutions like the ICC are treating it as a state? So to conclude, 3 points. We need to distinguish between legal principles on the one hand and morality and law and policy on the other hand. Statements of law by political bodies, whether it be the EU or any other political institution, need to be treated with a certain degree of skepticism. Secondly, I would say that applying legal principles to complex situations like the Israel-Palestine conflict requires looking at the totality of the situation and all of the facets involved, historical, political, even religious. The complexity of the facts on the ground, coupled with the generality of the legal principles, means that it's very rarely that law will prescribe a specific solution to any problem. And my third point to conclude is that none of the EU's parameters that I've mentioned are either mandated by international law or required by international law. And in fact, by imposing those parameters, as Europe is doing, Europe is arguably infringing on Israel's right to sovereign equality. And it's not just Israel's right, by the way. I believe it's infringing on the rights of, for example, Arab Palestinians in East Jerusalem, who also don't want to necessarily be part of a Palestinian state. So the fair application of international law is not just a question of defending Israel. I think it's a question of defending the interests and the rights of everybody involved in this conflict. Thank you.
Thank you, Andrew. So